Following is the complaint filed by attorney for Holy Cross and ADW Joseph Suntum of the law firm of Miller, and Canby against the Maryland Department of Transportation, State Highway Administration in the Circuit Court for Montgomery County, Maryland.
Court for Montgomery County, Maryland. Case number C15 CV 24004495. Roman Catholic Archbishop of Washington and his successors in office, a corporation sole, Holy Cross Catholic Church, Garrett Park, Incorporated, and Holy Cross Catholic Church, Garrett Park, Incorporated. Plaintiffs versus Maryland Department of Transportation State Highway Administration defendants. Complaint and demand for jury trial. Canby Chartered brings this complaint against the defendant, Maryland Department of Transportation State Highway Administration, and states, parties. 1. The plaintiff, Roman Catholic Archbishop of Washington, and his successors in office, a corporation sole, is the record fee simple owner of the real property at 4900 Strathmore Avenue, Garrett Park, Maryland, 20896, property. The plaintiff holds title to the property for the use and benefit of Holy Cross Catholic Church, Garrett Park, Inc., Holy Cross. Then, the plaintiff, Holy Cross Catholic Church, Garrett Park, Inc., is the beneficial owner of the property. Sitting, the defendant, Maryland Department of Transportation, State Highway Administration, MDOT, SHA, or state, is an agency of the state of Maryland. Count 1, inverse condemnation, PTA. The plaintiff incorporates paragraphs 1 through 3 above. On or about May 18, 2018, the defendant, MDOT SHA, requested the plaintiff to grant it a right of entry onto a portion of the property for the public purpose of constructing public drainage facilities within its right-of-way running along Strathmore Avenue, with the western portion of the drainage facility extending onto the property. The eastern portion of the drainage facilities were not to encroach onto the property. MDOT SHA promised to negotiate the terms of a perpetual easement in favor of the defendant for purposes of the defendant performing maintenance on the drainage facility. The entry agreement was not to be construed as a conveyance of a real property interest or state the compensation that the plaintiff would be entitled to receive for the easement to be acquired. The defendant represented to the plaintiff that it would negotiate and pay just compensation to the plaintiff after construction of the drainage facilities. In reliance on the defendant's representations, the plaintiff executed an entry agreement with the defendant, granting the defendant and/or its contractors the right to enter upon the property to construct the proposed drainage facilities. A copy of the entry agreement is attached hereto as Exhibit 1 and incorporated herein. The entry agreement expressly provided that the plaintiff was not relinquishing its rights to compensation for granting the right of entry, or any other rights the plaintiff had to compensation. Rather, all such rights were expressly reserved. Although the drainage facilities along Strathmore Avenue were designed to be located within the state's right-of-way, construction of the facilities would require the temporary removal of the plaintiff's fence, which was in place along the property line. The state agreed to replace plaintiff's fence in the same location along the property line upon completion of construction. The state, without permission from or notice to the plaintiff, installed the drainage facilities along Strathmore Avenue, outside the state's right-of-way and on the plaintiff's property. Contrary to the state's representations and contrary to the entry agreement plans. Further, the state failed to reinstall plaintiff's fence along the property line as the state had represented would be done. The state acknowledged that the drainage facility was improperly installed on the plaintiff's property, but it was reluctant to incur the expense of relocating the facility where it was designed to go. The defendant requested that the plaintiff enter into negotiations concerning whether the drainage facility would need to be relocated or allowed to remain in place with appropriate compensation paid to the plaintiff for the required permanent easement, replacement of plaintiff's fence, and repair of the plaintiff's property. 16. The defendant repeatedly acknowledged to the plaintiff that just compensation is due to the plaintiff for the easement and promised to pay the plaintiff compensation for the easement, but Bass failed to do so. 17. Notwithstanding the state's repeated acknowledgments of its ongoing trespass and its promises to pay just compensation to the plaintiffs and replace the plaintiff's fence to its original location, the defendant recently began contending that it does not owe compensation for the trespass or the portion of the easement running along the frontage of the property on Strathmore Avenue. The defendant now contends that the plaintiff, when it included a minimum restriction line as part of a 1961 subdivision that noted the potential for a future street widening, dedicated that portion of its property to the state, despite there being no recorded dedication of any portion of the property. 18. MDOT SHA took valuable property interests from the plaintiff for public use without paying the plaintiff just compensation. 19. MDOT SHA now refuses to pay the plaintiff full just compensation for the property rights acquired and the diminution in value its taking has caused to the remainder of the property. The taking of the property by the defendant for its drainage facilities without payment of just compensation constitutes an inverse condemnation of the property for which full just compensation is due. The plaintiff has been deprived of valuable property rights and incurred damage to the value of the remainder of its property without just compensation in violation of its rights under the United States and Maryland constitutions. The plaintiff has suffered and continues to suffer substantial damages as a consequence of the defendant's wrongful actions, including but not limited to loss of use of real property, diminution in value to the remainder of the property, legal fees and costs. Wherefore, the plaintiff demands judgment against Maryland Department of Transportation, State Highway Administration for the full amount of just compensation due for the taking of its private property, plus consequential and ancillary damages, attorney's fees, costs of this action, and such other and further relief as the court deems appropriate. Post. Count 2. Negligent misrepresentation. 23. The plaintiff incorporates paragraphs 1 to 22 above. P. 24. The defendant solicited the entry agreement by representing to the plaintiff that it would pay the plaintiff for the value of an easement through all the property required for its drainage facilities, including the portion of the property running along Strathmore Avenue. P. The plaintiff reasonably relied upon the defendant's representations that it would pay compensation for an easement through the entirety of the property required for the construction of its drainage facilities. P. 26. The plaintiff would not have granted the defendant the right of entry if the defendant had advised the plaintiff that it did not intend to pay compensation for an easement through the property taken along Strathmore Avenue. The defendant, as an agency of the state of Maryland, had a duty of care to accurately advise the plaintiff of the property for which it intended to pay compensation in consideration for the plaintiff granting the defendant an immediate right of entry to construct its drainage facilities. The defendant repeatedly represented, both before and after construction of the drainage facilities, that it would pay the plaintiff compensation for an easement through the entirety of property required for its drainage facilities. The defendant was negligent in its assertion of these false promises to pay. The defendant intended the plaintiff to rely on its representations, and the defendant knew that the plaintiff would rely on its representations and that the plaintiff would rely on its representations. The defendant's receipt of the requested immediate right of entry from the plaintiff was received in reliance upon the defendant's representations, and the plaintiff was justified in relying on the representations made by the defendant. As a result of the defendant's negligent representations with respect to what the defendant would pay compensation to the plaintiff for, the defendant was substantially benefited and the plaintiff was substantially damaged. Wherefore, the plaintiff demands judgment against Maryland Department of Transportation, State Highway Administration, in excess of $75,000, for the full amount of compensation due for the entire property required for construction of its drainage facilities, plus consequential and ancillary damages, attorney's fees, costs of this action, and such other and further relief as the court deems appropriate. Respectfully submitted. Miller, and Canby. Joseph P. Suntum, counsel for the plaintiff. Demand for jury trial. The plaintiff demands a trial by jury of all issues raised in this complaint. Signed, Joseph P. Suntum.
Is the first amended complaint in the case of Holy Cross Church versus the State of Maryland Department of Transportation and State Highway Administration. It was filed on October 8, 2025.
Court for Montgomery County, Maryland. Case number C-15-CV-24495. Roman Catholic Archbishop of Washington and his successors in office, a corporation sole. Holy Cross Catholic Church, Garrett Park, Incorporated, and Holy Cross Catholic Church, Garrett Park, Incorporated, plaintiffs. Versus Maryland Department of Transportation, State Highway Administration. First amended complaint. The plaintiff. Roman Catholic Archbishop of Washington and his successors in office, a corporation sole, for the benefit of Holy Cross Catholic Church, Garrett Park, Inc., and Holy Cross Catholic Church, Garrett Park, Inc., by their counsel, Joseph P. Suntum and Miller and Canby, chartered, and pursuant to Rule 2341A, amends its complaint against the defendant, Maryland Department of Transportation State Highway Administration, and states. Parties. 1. The plaintiff, Roman Catholic Archbishop of Washington and his successors in office, a corporation sole, is the record fee simple owner of the real property at 4900 Strathmore Avenue, Garrett Park, Maryland, 20896, property. The plaintiff holds title to the property for the use and benefit of Holy Cross Catholic Church, Garrett Park, Incorporated. 2. The plaintiff, Holy Cross Catholic Church, Garrett Park, Incorporated, is the beneficial owner of the property. 3. The defendant, Maryland Department of Transportation State Highway Administration, MDOT SHA, is an agency of the state of Maryland. Count 1. Inverse condemnation. 4. The plaintiff incorporates paragraphs 1 through 3 above. 5. On or about May 18, 2018, the defendant requested the plaintiff to grant it a right of entry onto a portion of the property for the public purpose of constructing public drainage facilities within its right-of-way running along Strathmore Avenue, with the western portion of the drainage facility extending onto the property. The eastern portion of the drainage facilities were not to encroach onto the property. 6. The defendant promised to negotiate the terms of a perpetual easement in favor of the defendant for purposes of the defendant performing maintenance on the drainage facility. The entry agreement was not to be construed as a conveyance of a real property interest or state the compensation that the plaintiff would be entitled to receive for the easement to be acquired. The defendant represented to the plaintiff that it would negotiate and pay just compensation to the plaintiff after construction of the drainage facilities. In reliance on the defendant's representations, the plaintiff executed an entry agreement with the defendant, granting the defendant and/or its contractors the right to enter upon the property to construct the proposed drainage facilities. A copy of the entry agreement was attached to the complaint as Exhibit 1 and is incorporated herein by reference. The entry agreement expressly provided that the plaintiff was not relinquishing its rights to compensation for granting the right of entry or any other rights the plaintiff had to compensation. Rather, all such rights were expressly reserved. Although the drainage facilities along Strathmore Avenue were designed to be located within the state's right-of-way, construction of the facilities would require the temporary removal of the plaintiff's fence, which was in place along the property line. The state agreed to replace plaintiff's fence in the same location along the property line upon completion of construction. The defendant, without permission from or notice to the plaintiff, installed the drainage facilities along Strathmore Avenue outside the state's right-of-way and on the plaintiff's property, contrary to the state's representations and contrary to the entry agreement plans. Further, the defendant failed to reinstall plaintiff's fence along the property line as it had represented would be done. The defendant acknowledged that the drainage facility was improperly installed on the plaintiff's property, but it was reluctant to incur the expense of relocating the facility where it was designed to go. The defendant requested that the plaintiff enter into negotiations concerning whether the drainage facility would need be relocated or allowed to remain in place, with appropriate compensation paid to the plaintiff for the required permanent easement, replacement of plaintiff's fence, and repair of the plaintiff's property. 16. The defendant repeatedly acknowledged to the plaintiff that just compensation is due to the plaintiff for the easement, and promised to pay the plaintiff compensation for the easement, but has failed to do so. 17. Notwithstanding the defendant's repeated acknowledgments of its ongoing trespass and its promises to pay just compensation to the plaintiffs and replace the plaintiff's fence to its original location, after a meeting among, inter alia, the plaintiffs and representatives of the defendant and Montgomery County on August 7, 2023, the defendant first suggested that it may not be obligated to pay compensation for the trespass or construction of its drainage facilities on the plaintiff's property running along Strathmore Avenue. The defendant further suggested that Montgomery County, which was interested in having a shared-use path along Strathmore Avenue constructed, may be willing to purchase the subject property from the plaintiffs. 18. The defendant now contends that the plaintiff, when it included a minimum restriction line as part of a Principle 6-1 subdivision that noted the potential for a future street widening, dedicated that portion of its property to the state, despite there being no recorded dedication of any portion of the property. The defendant took valuable property interests from the plaintiff for public use without paying the plaintiff just compensation. The defendant now refuses to pay the plaintiff full just compensation for the property rights acquired and for the diminution in value its taking has caused to the remainder of the property. The taking of the property by the defendant for its drainage facilities without payment of just compensation constitutes an inverse condemnation of the property for which full just compensation is due. 22. The plaintiff has been deprived of valuable property rights and incurred damage to the value of the remainder of its property without just compensation in violation of its rights under the United States and Maryland Constitutions. 23. The plaintiff has suffered and continues to suffer substantial damages as a consequence of the defendant's wrongful actions, including, but not limited to, loss of use of real property, diminution in value to the remainder of the property, legal fees and costs. Wherefore, the plaintiff demands judgment against Maryland Department of Transportation, State Highway Administration, for the full amount of just compensation due for the taking of its private property. plus consequential and ancillary damages, attorney's fees, costs of this action, and such other and further relief as the court deems appropriate.
Lawsuit filed by A.W. versus the State of Maryland, H20 2024. Holy Cross Catholic Church, Garrett Park, Inc., Roman Catholic Archbishop of Washington, successor in office, a corporation sole. Writ of summons, new case, 8/20/2024. Notes below by George C. Martin, Jr., 2/1/2025. The question is, what did we, HC, sell that we are deserving of compensation? Before commenting on each count made by the Diocese's counsel, Joseph Suntum, I note that the discovery and preliminary matters stretch from November 2024 through the summer 2025. It is a fact that the Archdiocese of Washington, ADW, abandoned their duty to protect Holy Cross, HC, and their own property in 2012. In 2012, the head of facilities for ADW, after reviewing the damage caused by the state, stated that they did not have the money to fight SHA. In 2016, I tried again to get ADW to participate in an effort with MC Highway and SHA officials to have the flooding stopped at HC. But once again, ADW failed to confront the state for their actions. This complaint reinforces my position that ADW abandoned their obligation to defend their property from the criminal actions of the state for reasons to be offered later. Without addressing the criminal trespass, property damage, and property confiscation, ADW appears to accept the state's right to occupy HC-ADW property. Incredibly, the complaint filed by ADW only focuses on the state's failure to pay compensation. ADW's history for over the last decade is to observe an institution that represents being an owner when convenient, and AWOL when convenient. In retrospect, had ADW remained AWOL for the entirety of this tale, HC would have been today in a far better condition. The malfeasance of ADW in granting the state access in perpetuity is in direct opposition to the demands I had been making on behalf of HC for over a decade. These demands were simple: stop flooding HC and contain your public stormwater runoff to within your ROW. As to my comments below, please read the item number first, then the comment. Where the type is bold, this is to highlight the fact that the wording is from the complainant's or ROE. Count number 1. As to item 1, 2, and 3, there appears to be something deceitful in the designation of HC as the party being described in the complaint as the beneficial owner. On September 17, 2024, a month after the original complaint was filed, ADW transferred and recorded HC as the sole owner of the parish property. I was told over a year earlier by ADW's General Counsel, Chris Anzadeh, that ADW was transferring the property to HC. The point here is that while in the original complaint filed in August 2024, ADW appears to be a party and HC the beneficial owner, HC is the sole owner within the month. Indeed, in the first amended complaint, filed in October 2024, the plaintiff's description remains unchanged. ADW remains shown as fee simple owner, and HC is the beneficial owner. This is a misrepresentation to the court. Also, if ADW is no longer owner of the property, ADW no longer has standing to sue and should be dismissed or withdrawn from the case. Why not wait a month where there would be no need to even mention ADW as a partner at all? Could it be that since HC was not informed nor consented to the contents of the complaint, it would not serve ADW's purpose to have only HC shown as plaintiff? As in all matters, it appears that ADW wants control. I have no doubt that the pastor of HC had no hand in the drafting of the complaint, or gave consent to the contents of the complaint. If, on the other hand, Father Weibel was fully informed and consented to the wording of the complaint, all of my questions here, directed to ADW, need to be answered by Father Weibel as well. If what I am saying here is true, Father Weibel inadvertently allowed the fox to enter the henhouse, to the detriment of HC. While inverse condemnation is proper, the words that SHA requested the plaintiff to grant it a right of entry implies a mutually agreeable and legally binding agreement, whereas the reality of the situation was, failing HC cooperation, SHA was to obtain access through duress. The state's method of obtaining the ROE agreement is sufficient evidence of extortion. The height of this duress was reached after we had done everything possible to get the state to contain their runoff in the row, including giving tours to 3 state delegates for them to see the damage caused by the state's flooding. It was to reach the point where Father Bookmeyer could no longer allow the HC schoolchildren to be exposed to mortal danger of the overflowing ravine reaching almost to the school doors. Despite putting the state on notice to the mortal danger of the flooding, HC capitulated to the demands of the state's ROE extortion agreement. At that time, I had advised Father Bookmeyer that the agreement was bogus, with no consideration, and was pure extortion, lacking any alternative to getting the state to act rationally. Let them install their shortcut to stop the flooding, leaving undeniable evidence of their illegality. As to items 4, 5, and 6, the operative words are public drainage facilities, i.e., HC, as a private property owner, has no obligation to assist the state in their duty to receive public stormwater. For what benefit would a private property owner have in receiving public stormwater? We have in our possession the Maryland hydrologist's plan that shows that the watershed area north of HC appears comparable in size to HC's own acreage. Furthermore, while the plaintiffs are shown as ADW and HC, as of September 17, 2024, both parcels incorporating HC parish property are, as of that date, shown as solely owned by HC. Therefore, as a first step in trying to amend and/or withdraw this complaint, ADW should be removed as a plaintiff in this action. As to, for the public purpose of constructing public drainage facilities within its right-of-way running along Strathmore Avenue, the new piping is not in the right-of-way, ROW, but primarily in the 1-acre parcel my son George discovered and brought to ADW's attention. This 1-acre parcel can be identified on the drawings as the area planned for future road expansion. All piping along Strathmore is within this 1-acre frontage parcel now owned by HC. And yes, it is anticipated that the future sidewalk will be within this 1-acre parcel to be acquired by the state through eminent domain, ED. Within a few months of having been illegally terminated by ADW, I was to understand that Joe Suntum was being engaged to handle the sidewalk ED effort. It was the furthest thing in my mind that he would be filing other claims. Again in 5, the state-caused flooding started in 2010. Chris Anzadeh started at ADW in 2015, so he was not involved in ADW's first abandonment of HC in 2012. It was ADW's rep, Richard Destalinsky, saying that they, ADW, did not have the money to fight SHA. However, he had to know that his employer had abandoned their duty to HC in 2012, and Richard's inaction in 2016. When my neighbor and MC council member Nancy Florine convened a meeting of both MC Highway and SHA officials. Richard again made no effort to confront the state. Nancy did her best to get the state to comply with what common sense dictated, but failed. By his own admission in this complaint, and unbeknownst to H.C., Chris, via Joe is talking about compensation from the state relative to the 2018 ROE agreement. It had been my position that there would be no discussion with the state about partnering with them to have access to our ravine. Our position was that the state had only one option, to replace the roadside retention ditches until they had completed their piping in the Strathmore Rowog. However, now that the shortcut is in place, there is no need for the retention ditches. It was increasing clear that they were intent on getting access to the HC ravine without offering one logical incentive for our cooperation. Employing duress through flooding HC was an effective weapon. As to items 6, 7, and 8, it is the norm, following the completion of the ROE task, to have a recordable conveyance agreement. HC has no record of any drafts submitted or promises made from SHA or ADW to negotiate the terms of a perpetual easement. And further in item 7, the entry agreement was not to be construed as a conveyance of a real property interest. If ADW had such discussions with SHA, this would be outrageously presumptuous of ADW, as without our HC involvement, there is no agreement, as we are shown to be parties in the complaint. And more importantly, as the beneficial party, HC would receive all damages awarded. However, if the claim is made of soft putty, as in this case, ADW could say they tried while being unaffected by any award decision. Having lived the intimidating tactics of the state and their selfish cost-saving venture for over 8 years, what motive did we have to cooperate with them? The answer is absolutely none. Here we draw the line with ADW, who did not live with what Father Bookmeyer and I experienced for 8 years. When reading the ROE statement that, in signing this agreement, grantor understands that it is relinquishing any rights to compensation for granting this limited right of entry, reinforces our position that the ROE is limited to entry, not of possessing any further rights. For ADW, we see that this door on compensation is not closed on rights, as the grantor may have to compensation. However, this wording is so vague as to be meaningless. With the flooding problem temporarily solved, SHA and ADW had a serious land use problem. As my email to SHA asserts, without a conveyance agreement, the state had no right to remaining on HC property. As for ADW, who was purported to represent the legal interest of both HC and ADW, made no effort to either confront the state for extortion or consult with HC on any alternate plans. Yes, I would allow a temporary use of the property by the state until they installed their permanent piping in their rowway, but for no other reason. It was my email to the Assistant General Counsel of SHA that finally opened the eyes of the one person at SHA that understood the gravity of the state's unrecorded piping being installed on private property. With HC having expended the entire cost for the restoration of their property, HC was going to seek full recovery for this cost to restore the property, plus property devaluation and punitive damages for the 13-year ordeal the state put HC through. Thanks to the gross ineptitude of ADW in entertaining discussions with the state for getting both of them out of their dilemma, HC was left with no real plans for recovery. Presently, the unrecorded and unresolved shortcut has the state and ADW in a deep hole with no honorable way out. As for items 7 and 8, this item is correct, as the entry agreement was not to be construed as a conveyance of real property interest or state the compensation that the plaintiff would be entitled to receive for the easement to be required. Why then would ADW demand compensation from the state for something that the ROE specifically identified as not an obligation of the state? Also, it appears that ADW is unaware of the fact that the ROE is simply a right of entry agreement and lacks all the particulars that one would expect to find in a normal agreement for conveyance of property. Also, since it appears that ADW is accepting the ROE as a conveyance document, why would they not have specified the very obvious need to state the all-important compensation amount to be paid by the state? And for the state to ponder, why would they think that they can enter a private property, causing horrendous damage in the process, devaluing the property in the long run, and upon completion, paying no compensation? For two lawyers to have engaged in an oral agreement with such enormous consequences is absurd. Like everything ADW has done at HC, it has been casual, sloppy, and unprofessional. Like a bull in a china shop, or walking into a bar, starting a fight, and leaving without suffering the consequences. For ADW to give Joe Suntum the marching orders to get some kind of compensation out of the state is a self-serving act of legal disengagement by ADW. As to items 9, 10, and 11. In item 10, we see that ADW's only hope for making a case is for some decision-maker to rule favorably on the ROE phase. Quote, "The plaintiff was not relinquishing its rights to compensation for granting the right of entry." To cling to such a tenuous phase in a major civil and criminal action provides little hope to the plaintiff's prior argument of implied intent. The ROE is no substitute for a properly prepared, mutually agreed upon transactional agreement. And again, the ROE warns, upon completion of work, the right of entry shall automatically terminate, or to rephase. This ROE agreement cannot be considered the transactional agreement you would like for it to be. Where in item 11, the statement, although the drainage facilities along Strathmore Avenue were designed to be located within the state's right-of-way, is contrary to the plans. As to the silly fence replacement issue, Mary Rhodes, ADW, was trying to put pressure on the pastor to pay either $11,000 or $14,000 to replace a section of fence the state failed to do. Note that in all matters relating to money, ADW, as owner, has not paid a cent. Mary's thinking was that this section of fence would expose the parish to the eventual adverse possession claim by the state in 20 years of about 7% of the Strathmore piping. Our position was, and is, why worry about only 7% of the 1-acre parcel when 100% of all the piping on the south side of Strathmore is on HC property? As previously noted, the pending sidewalk eminent domain claim by the state should all but absorb the entire 7% fence replacement area. As to 12, 13, 14, and 15, there is no purpose for ADW to rehash the failure of the state to replace the fence. Not only is there no legal obligation on the part of HC to receive the state's stormwater, the piping serves no benefit to HC for the long term. Short term provides relief to HC until piping placed in raw. As stated above, it is the entirety of the piping on the parish property that should be the focus, not just the 7% fence replacement section. The state's primary offense to HC is the 220 feet of 3-foot diameter piping that runs perpendicular to Strathmore. The plans attached to the ROE clearly show the piping running south, away from Strathmore and away from their raw. These 220 feet of piping, plus the Ravine Creek bed leading off the HC property, is the real shortcut. In order to grasp what is written in item 12, You would have to believe that had the state kept all of their piping within their RAW, there would be no crime, and you would be right. However, since the plans are attached to the ROE agreement and are meant to be complementary, this item makes no sense. Our whole position was from the start, stop the flooding and put your piping in your ROW. Clearly, this item 12 was not proofread for content. As a follow-up to item 12, item 14 only further confuses the matter by stating that the drainage facility was improperly installed on the plaintiff's property, but was reluctant to incur the expense of relocating the facility where it was designed to go. The complaint drafter is correct in that the Strathmore piping running east to west is further south than the drawings indicated, but that will likely be resolved in the sidewalk eminent domain matter next year. However, that is not the major crime, as it is the long-term perpendicular piping running south, aka the shortcut, that needs to be removed, with the piping running parallel with Strathmore. As an aside, we have no answer to the question whether the parallel piping could be used as part of the piping we are demanding to be placed in the routeway upon the eminent domain acquisition. In 16, that Chris Enzadeh would even think about compensation from a thief before dealing with the criminality of the state is absurd. The criminal action liable for this claim, the complaint seems to serve no other purpose than to cover up a more serious action. In 17, as mentioned above, we asked Mary Rhodes, ADW, to demand from the state their proof of ownership of the 1-acre frontage parcel used for their piping. The state could not show proof then, nor have they amended this response. I had chastised Mary for hanging on to her apparent hope that the state could somehow rationalize their actions, i.e., since ADW had not confronted the state on their criminal actions, ADW was clearly protecting the state from being charged with a crime. The day the state chose to fill in the retention ditches was the day the state's program of duress was in play. This program of duress had started in 2010 and has never stopped to this day, as the unauthorized and unrecorded piping remains in HC soil. With an ally like ADW to provide cover, both the state and ADW have now invested so much time and effort in a criminal matter. I see no honorable way for them to get out of it. In 18, 19, 20, 21, and 22, the complaint's argument for compensation provides no foundation for a right of recovery. Had ADW produced a document showing that the state failed to perform something, they may have something to start with. However, what ADW has done by displacing my pending punitive damage claim with what purports to be an understanding for compensation, they have replaced HC's claim against the state for punitive damages simply with diminution in value. An arbitrator having ruled on res judicata cases in the past, i.e. the claim has already been adjudicated, we could be precluded from being able to file our claim. Should this happen, it would not only be unjust, but it could also result in HC not receiving millions of dollars in compensation due to the incompetence of ADW. As in the case of ADW's unethically taking over my efforts in support of HC, ADW's impulsive acts are recklessly hurting HC and making the Cardinals' administrative team look incompetent. If this is Joe Suntum's case and not ADW's case, where is there evidence of communication and consent on this? The most important administrative matter in HC history. Section A, Count 2, Negligent Misrepresentation. Unlike what I related on Count 1, It would seem to be of little value to comment on each item, as it would appear that there is a reoccurring theme here, with one exception. Unlike in Count 1, we see for the first time the words of the entirety when speaking of easements. This was also the first admission that ADW had a story to tell, unrelated to the failure of the state to stay within their row. While elevating the failure of the state to stay within their row, which is of little importance, the plan accompanying the ROE agreement is explicit in revealing what is at the heart of the wrongdoing of both the state and ADW. Count 1. The sole focus appeared to be on the failure of the state to stay within the Strathmore row. In Count 2, we see the state anticipating acquisition of the land for the sidewalk/side path that will likely cover the piping under the eminent domain action. Ergo, we see little in Count 1 for the plaintiff to seek compensation. Whereas in Count 1, the defendant has definitive plans showing the piping within the 1-acre northern parcel extending into the primary southern HC parcel. It fails to show the full extent of the easement for the entirety. What the plans do not show is that while the piping running south ends at the ravine creek bed, there is no complete shortcut without incorporating the ravine creek bed. To subordinate the state's insane actions in illegally confiscating HC property by offering to them a way out, without first advising HC what they, ADW, did, and then failing to define in the complaint why the state owes anything, is malfeasance. The complaint stated in item 26 that the blank would not have granted the defendant the right of entry if the defendant had advised the plaintiff that it did not intend to pay compensation. This statement may be correct if ADW is speaking, but not if it is HC, the beneficial partner and presently the sole owner, speaking. Not only am I confident that the parish administrator did not discuss compensation with the state, it has always been HC's sole position that the state was to contain their stormwater within their ROW. Any discussion with the state about compensation would be contrary to HC's consistent position for the state to contain their stormwater within their ROW, period. For ADW to suggest that ADW was considering compensation, they would have had to have had a substantial file on this matter, including HC's participation in this negotiation, which I challenge them to produce. Besides the word entirety, the admission of item 28 that the defendant repeatedly represented, both before and after construction, that it would pay the plaintiff compensation, entirety of property, is stunning. While I have stated many times that you have to assume that ADW had to have allowed something of value to be offered to the state, or they, ADW, would not have demanded compensation. Here we have that admission of a deal of something. Since we are describing discussions between lawyers, to fail to memorialize something of such value that court action is necessary for resolution is also stunning. It would seem that in using a word such as negligent, you would think that the drafter of the complaint would ponder his/her role in providing a description and cost of what was to be exchanged. If you really want to see how a lawyers can create knots in their assertions, read item 30 at least 3 times before concluding what it means. Aside from the strain to make item 30 understood, is the underlying of authority necessary to engage in such a transaction by both parties. As for the state, who is this unknown authority who will have to have known how SHA fraudulently acquired access to HC's ravine? This knowledge of the state's wrongdoing is public knowledge that will follow this piping caper to its conclusion. Knowing that HC had demanded that the state contain their stormwater within their RAW, HC had no obligation to receive the state's public stormwater. First amended complaint, 10/8/2024. In commenting on this amendment, it should be noted that the previous comments on the complaint were done weeks to even months ago. In order to obtain copies of the defendant's motion to dismiss and count 3, we had to go to a library in Rockville, Maryland, which we did on January 15, 2024. Unfortunately, having found the original complaint so lacking in substance and a foundation for what the plaintiff is seeking, I see no effort by the drafter to help identify what changes were made. Small. Therefore, I needed to check, line by line, what was amended. This is an extraordinary document, as it finally exposes in more understandable terms what is really going on here. The only thing that was clear in the original complaint is that ADW had sold something, as ADW was looking for compensation. Since at the time of the original complaint, 8/19/2024, HC was shown as both the party with ADW and the beneficial owner. In this amended complaint, we have more detail on what ADW may have tried to sell. What is still lacking is ADW's right and/or authority to sell something belonging to HC, the beneficial owner. If ADW had tried to sell something, there would be a need to consult with and to have consent from HC. Furthermore, the need to have a conveyance agreement on which ADW would reference as the foundation for demanding compensation. No such consent from HC or to an agreement is referenced. In the original complaint, HC was not the owner of record. However, a month later, they were the sole owner of the 2 parcels comprising the HC property. I would like to think that HC read the original complaint and asked to have their name removed as party. While I had still to hear back from Peter Condren, as an advisor to HC, whether he approved of this original complaint, I would still like to know. Also, in the first paragraph, item 1 of the amended complaint, it states that the plaintiff ADW is the record fee simple owner, and further that the plaintiff holds title, which are both factually incorrect when this amended complaint was filed. In stating in item 2, Holy Cross Catholic Church, Garrett Park, Inc. is the beneficial owner of the property, is superfluous as they are in fact the sole owner. In count 1, items 5, did not change, but required rereading numerous times for meaning, but it still makes no sense. At the time of the writing of this amended complaint, the drafter had to know that both the northern and southern parcels were owned by HC. The question remains, why did the drafter continue to reference the western and eastern portion of the piping when the entirety of the piping is on HC property? It appears that it is the intent of the drafter to make one think that, as Mary Rhodes had hoped, that the northern portion belonged to the state when even the state denies owning that parcel. In retrospect, we can see that ADW, in thinking that 1, the state controlled the northern parcel holding 80% of the piping, and 2, having failed to read that the ROE agreement is not a conveyance agreement, and 3, while not knowing that they, ADW, owned the northern parcel at the time of the ROE signing, and 4, having never shown any regard for HC Parish and the law in my fight against the state's criminal trespass, property damage, duress, extortion, taking, and restoration. ADW simply allowed the state to have access to HC's ravine without consultation or consent of HC. As to item 6, it is humorous in stating that perpetual easement for maintenance on the drainage facility, when these pipes require no maintenance. However, what is not humorous in this item is the defendant promised to negotiate the terms of a perpetual easement Did ADW think for one moment about the fact that over the years that several HC pastors and myself were doing their work for them in confronting the state while they were making a deal behind our backs? That they thought that the state was entitled to anything is absurd. Why would the owner of the property negotiate with the thief that over a 6-year period mocked the law by wantonly destroying HCADW property? For me, this was a gotcha moment, as I now had a way to stop the flooding, while the state, without thinking, had provided to the victims, ADWHC, in agreement, ROE, without consideration. In essence, the ROE agreement was an admission of extortion, as the piping into HC property serves no benefit to HC, nor was any consideration stipulated. Two attorneys regularly engaged in land use deals, a lawful purpose and compensation are elementary. In the end, where the state was prepared to give HC a compensation package as an admission of wrongdoing, ADW had previously engaged in some sort of oral understanding allowing access. Realizing that HC had the admission by the state of wrongdoing, ADW was forced to generate the original complaint as a cover-up of their actions. As to items 7, 8, 9, 10, 11, 12, 13, 14, 15, and 16, there is little substantive changes. However, on the rereading of these items, I am more convinced than ever that the whole subject of the modest misplacement of the Strathmore piping was a smokescreen to give cover to the shortcut giveaway. Again, at the time of the original complaint, with no amendment change thereafter, the Strathmore piping, whether per plan or actually out of the ROAG, is in the northern parcel presently owned by HC. While ADW wants to make an issue of the state failing to stay within their ROAG, the beneficial interest, HC per original complaint 8/20/2024, and sole owner, HC per deed, recorded HC is the only party who has standing to sue. As to item 17, on line 3 of the original complaint ending ... original location, the defendant recently began contending that it does not owe compensation for the trespass or the portion of the easement running along the frontage of the property on Strathmore Avenue. H has been changed. The amended complaint states ... original location, after a meeting among inter alia, the plaintiffs, and representatives of the defendant, and Montgomery County on August 7, 2023. The defendant first suggested that it may not be obligated to pay compensation for the trespass or construction of its drainage facilities on the plaintiff's property, running along Strathmore Avenue. The amendment version is very revealing as to who knew what and when. When Father Weibel advised me soon after his arrival that the team was reviewing my efforts in confronting the state, I knew that my efforts over the last 13 years were coming to an end. I assumed that the team was composed of the two discredited ADW reps, and likely the finance committee members John Shazer and Peter Condren. When my son and I met with Chris Enzadeh and Father Weibel, we heard that they were to meet with the county the following week on August 7, 2023. This was curious, as the only function concerning the county was that they were handling for the state any matters involving the new curb and sidewalk work. I was not aware that the legal rep for the state was to be at this meeting. Since I was the only person who was intimate with all of the details of the state's trespass, I demanded that I see notes from this meeting in order to provide guidance to the new administrator. I had not been invited by the team to attend. Item 17 concludes by stating in the original complaint, the defendant now contends that the plaintiff, when it included a minimum restriction line as part of a 1961 subdivision that noted the potential for a future street widening dedicated that portion of its property to the state, despite there being no recorded dedication of any portion of the property. Before continuing on to how this sentence was amended, I am reminding the reader of my admonishment to Mary Rhodes to stop trying to help the state rationalize the ownership of the northern parcel of HC. Also, I have to give the drafter credit for creative writing as the potential for a future street widening, despite there being no recorded dedication, as the potential means what could happen in the future. As to the amended sentence, the plaintiff states, the defendant further suggested that Montgomery County, which was interested in having a shared use path along Strathmore Avenue constructed, may be willing to purchase the subject property from the plaintiff. For the first time, the plaintiff confirms my oft-repeated remark that the side path, sidewalk, would ultimately be incorporated within the state's eminent domain ED claim. With the piping below, it had become the norm for the county, where the opportunity presented itself, to install side paths, aka bike paths, with a substantial part of both complaints devoted to the Strathmore piping, where, due to the fact that ED money was always pending, ADW was to mute this unstated matter. To state in this amended complaint that may be willing to purchase the subject property is to have you believe that the thief who confiscated your property is considering purchasing that which they stole, and it just so happens where the side path is planned. I assume that those HC members in attendance at this meeting did not know that they were being set up for the ultimate goal of both ADW and the state, i.e., the giveaway. In essence, if I can get you, HC, to think of me as just an interested buyer instead of a thief, and that you are not aware that the funds to pay for the stolen property comes from the pending ED claim, how sweet is that? And as a bonus, if again you do not think of me as a thief, maybe we can make a deal on the balance of the piping and creekbed easement. As to item 18, this has been completely replaced with, the defendant now contends that the plaintiff, when it included a minimum restriction line as part a 1961 subdivision that noted the potential for a future street widening, dedicated that portion of its property to the state, despite there being no recorded dedication of any portion of the property. Again, we see the Mary Rhodes dilemma, where if only they, ADW, had ceded this northern parcel to the state in 1961, there would not be an issue. Yes, had this parcel been ceded to the state in 1961, ADW would not have claimed that the state trespassed, as the right to allow for the shortcut was in progress. But the state did not own this parcel, nor the southern parcel. Since HC owns both parcels, the filing of a complaint is valid, but grossly understated as to damages being sought. ADW, discovering late this fact, will be shown to have worked against the best interests of HC. As to item 19, there is an interesting distinction. The original item states, MDOT SHA now refuses to pay the plaintiff full just compensation for the property rights acquired and the diminution in value its taking has caused to the remainder of the property. The amended complaint simply says, the defendant took valuable property interests from the plaintiff for public use without paying the plaintiff just compensation. While the original complaint dealt primarily with the northern parcel, which is solely owned by HC, the attempt to tie the diminished value of the southern parcel made no sense, so diminished value was deleted. In item 20, we see an attempt by the drafter to correctly insert the diminution in value for the remainder of the property. In stating remainder, This is the first attempt by the drafter to tie both parcels together. In item 21, 22, and the added 23, the writer cannot discern changes in the amended complaint worth note. Count 2, negligent misrepresentation. In the following review between the original and the amended, the original item 23 does not exist in the amended version. Therefore, starting with the original 23 is matched with the amended 24, 23, 24. Items 23, 24, 24, 25, 25, 26, 26, 27, 27, 28, 28, 29, 29, 30, 30, 31, 31, 32, and 32, 33 were not amended. There was no item 33 in the original complaint. Therefore, we continue with the amended complaint. In item 33, the plaintiff asserts at the end, the defendant was substantially benefited. The plaintiff was substantially damaged. In item 34, the defendant had actual and constructive notice of the plaintiff, claim for compensation, and the circumstances to giving rise to the plaintiff's claim within 1 year of the construct of the subject drainage facilities on the plaintiff's property. This SOL issue is almost comical, as when this matter was being reviewed in court on the defendant's motion to dismiss on SOL grounds, the plaintiff, ADW, was no longer the owner of the property. Arguably, the tolling on this event could have started as early as 2010 if HC had known the true intent of the defendant by observing the flooding of their property. How can the state assert a statute of limitation defense when their criminal actions and attempts at adverse possession from 2010 to this day have been ongoing without apology? Ending. Conclusions on counts I, 2, and etc. Amended 3. The whereof the original and amended count 1 states, for the full amount of just compensation due for the taking of its private property, plus consequential and ancillary damages, attorney's fees, costs of the action, and such other and further relief as the court deems appropriate, is identical. The whereof the original and amended count 2 states, for in $75,000 for the full amount of compensation due for the entire property required for construction of its drainage facilities, plus consequential and ancillary damages, attorney's fees, 1, is identical. There being no count 3 in the original complaint, the first amended complaint states, wherefore, plaintiff demands ejection of the defendant and the drainage facilities from the plaintiff's property, plus consequential and ancillary damages, attorney's fees, costs of this action, and such other and further relief as the court deems appropriate. The following is an extraordinary admission by AW to restore HC's position prior to AW's takeover. This is the proper and only response you can demand of an adversary who has trespassed your property, recklessly damaged by flooding for years, your property as a weapon of duress in an attempt to gain access to the plaintiff's ravine for discharging the state's public stormwater, subjected the plaintiff to extortion should the plaintiff fail to sign the state's right of entry, AGEME. A highlighted summary of the amended complaint. Parenthetically, I'd confined you every day. Realizing that the intention behind the draft was to file such a poor original complaint 1 month before their client, HC, was to become the sole owner in 3 months, while keeping the non-consequential demand that the defendant failed to stay within their roadway, the plaintiff makes a stunning pronouncement, i.e., plaintiff demands ejection of the defendant and drainage facilities from the plaintiff's property. 3. Not only is there no predicate for this sudden addition in the claim by the plaintiff, but it so subordinates count 1 and 2 as to make both meaningless, if the state wished to hold their access. Why do we not see a counterclaim by them? What is the endgame? 4. Did ADW or Suntum consult with and receive consent from Father Weibel before the original and/or the amended complaints were filed? 5. With HC recorded as sole owner on 9/17/2024, why would the drafter state that ADW is the record fee simple owner of the real property on 10/8/2024? Did the drafter simply not know that they, ADW, no longer owned the property, or did they? 6. As you may recall, it was my conclusion, after reading the original complaint, that there was no obligation owed by the state to HC in that complaint. Yes, while there is yet to be seen a credible claim for damages inflicted against the parish, at this time, there was no conveyance agreement between these two parties. The amended complaint is equally defective as the plaintiff has no standing on the filing of this complaint on 10/8/2024, as HC was recorded as the owner on 9/17/2024. 7. In filing the amended complaint, the attorney is obligated to present the true facts to the court. The attorney's failure to be truthful can result in being disciplined. We can see at the conclusion of the amended complaint that the unrecorded plaintiff, ADW, is demanding the ejection of the defendant. They have come full circle. Should this most recent complaint survive its defects to stay in the court system, their last gasp supports my position that the defendant contained their stormwater within ROW. Had ADW simply stated what any property owner would have demanded if violated by his neighbor, this would have been over in 2012. The ADW staff could not seem to get my flooding memo up from the second floor to the third, for the Cardinal to take action. Yes, we HC have finally been vindicated for our position taken 13 years ago, i.e., stay off of our property. But thanks to the arrogance and selfish motives of both the state and ADW, they are both in a mess of their own making, and HC remains to be the victim of their wrongdoing. As an aside, is the use by ADW of Joe Suntum's office to deliver these meritless complaints to the court, simply to cover ADW and the state's misdeeds. Yes, Joe failed in his due diligence obligation to verify what ADW was shoving on them, but ADW did the unforgivable by trying to distance themselves from this whole affair. This follows a familiar theme, i.e., when ADW wants to act as owner or go AWOL, they view it as their prerogative. I think of all the years I tried to get ADW to respond to the state's actions, only to see HC left with holding the bag. Entitlement. The case for entitlement has been laid out in the narrative history of the state's criminal confiscation of a portion of HC property. End of my analysis of the complaint. Quantum. Upon completion of the state's piping being installed in their rawway, and the removal of all piping related to the shortcut, and restoration of the area disturbed, damages being sought of $30 million incorporates the aggregate of property damage restoration caused by flooding, legal costs, and punitive damages. It is further understood that should any piping in the 1-acre frontage parcel be usable for the ROW installation, this would be acceptable to the plaintiff. However, should the defendant fail to install their piping in the ROW and remove their shortcut piping and the restoration of the disturbed area by December 31st, 2028, liquidated damages of $5,000 per day would be assessed thereafter. Option available to the defendant. The shortcut piping may remain in place. Should the defendant accept this option, the damages being sought of $30 million incorporates the aggregate of property damage restoration due to defendant-caused flooding. Devaluation of property value due to in-place state-installed piping. Legal costs. Costs associated with recordation of a properly prepared right of access agreement. P. It should go without saying, did ADW give even a moment's thought as to how much would be the cost for the state to install their required piping in the RAW in 2023? That would be an elementary starting point as to the option value, where the state must pay a monetary sum for something that is already in place. The estimated cost for the RAW in 2010 must have been tremendous for the state to risk criminal prosecution to avoid this expense. Was there any effort on ADW's part to even inquire of SHA to see the RAW design and conceptual estimate for piping running 10 times longer in a busy roadway than the shortcut? Ultimately, what do we have? We see no agreement between the parties for which the complaint depends on to be heard. Yes, as the complaint states, and I fully subscribe, complaint and demand for jury trial for a new complaint is in order, but only when this case is properly prepared for filing. Thanks to the actions of ADW in unethically taking over my role for HC to reverse the criminal actions of the state and to seek damages, the parish is now stuck in a worthless lawsuit of ADW's creation. In my over 40 years as an arbitrator, I have never seen a claim made so lacking in merit as what ADW is asserting. Not only is it pitifully weak, it manages to expose both ADW and the state in participating in an attempted property agreement, lacking in authority and documentation to be valid. The state, after criminally trespassing, causing great damage, followed by 6 years of duress leading to extortion, balks at paying compensation for something ADW had no authority to sell. The public should know what the state has done to one private property owner, and that action reflects an organization that shows the complete disregard for the law. The state's actions remain open and unresolved to this day. As to ADW, from the beginning, I only needed to have the cardinal make a call to the governor, which even that they failed to do.